Every day in the USA, people find themselves in court. Every day in the USA, people find themselves in court.
All right, we're back. People click right on that. Chibi. I don't know what that means. All right. Our next matter is Sturgis Housing Limited, Dividend Housing Association and Limited Partnership. It's a lot. I usually just say Sturgis Houses Limited, Sturgis Housing Limited. They are represented by attorney Samantha Sprague from the Gann Law Firm in Lansing. And also present is Cindy Pennington, their manager. With us here at the courthouse in the conference room is Ora Goodsell. Mr. Goodsell, can you hear me?
Yes, I can.
And Ms. Goodsell, can you hear me?
Yes.
And Cheyenne Goodsell is here by Zoom. I received a letter about 1 minute ago from Cindy Pennington to Mr. Goodsell, advising that Cheyenne left in October of 2023. Is that true, Ms. Goodsell?
Yes, it is.
And so you're no longer there?
No, I have not been.
All right, let me take a minute and make some notes here, and then I've got to tell you both something. Everybody that needs to be here is here. You are both tenants in a land case, and you're in a case that you pay rent. In your case, you have legal rights. In this matter, cannot afford an attorney that will the other right here is the right here for waiver. We will tell you what provided. You're asking to be evicted from a residential property because you haven't been able to pay the rent. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated agency, a housing assessment and resource agency, or a federal homeless veteran program. I just talked to a lady earlier this morning that had contacted all of those agencies, except the veterans one. You should have received that information regarding that with your summons and complaint, and I did send you that. You may be able to reach an agreement with your landlord if the landlord is agreeable by alternative resolution. So far, that's never happened, but it might. And we would refer you to the Citizens Mediation Authority or Citizens Mediation Services, Inc. If you do reach an agreement with the landlord, that means the case gets dismissed. There would be a form called a conditional order of dismissal that could be filed with the court. We would either provide you with that form or tell you where to find it. So let's start, Ms. Sprague. What is the current arrearage?
Currently, we do show that there is past due rent in the amount of $3,546.70. There are currently cost of $205 for court costs. That is not inclusive of the service fee, which we have not received yet, for a total due of $3,751.70.
There is no proof of service in here, but the defendants are both here, so I guess I'm not gonna be concerned about that.
I called the courthouse and got paperwork.
Oh, did you?
Yeah,
Well, you're
I never
here,
received
so,
nothing.
well, I don't see a proof of service, but you're here, so it's not an issue. I'm not gonna charge you for proof of service if they didn't serve it. Anyway, this is a non-payment of rent. If you don't pay the rent, you could be compelled to move. Ms. Goodsell, you don't care because you've already moved.
Right.
Mr. Goodsell, this is of concern to you. Now, Ms. Pennington sent you a letter. All right, we're back. People click right on that.
Every day in the USA, people find themselves in court. day in the USA, people find themselves in court.
Dagger goes in. How are you? You hear him for now or no? So I think he asked to be brought in person.
Okay.
But the jail didn't bring him. So I can bring him on Zoom and ask him if it's okay, or if he does, if it's not okay with them, we can adjourn it.
You wouldn't be able to just be brought over later or,
Yeah, today sometime.
yeah, that's fine.
Yeah, but I don't know that they would be able to do it right this second. I apologize.
My laptop died, I'm gonna go grab a charger.
Okay.
Judge, I have to pop over to Old Saber real quick and then I'll be right back.
Okay.
But if he is okay with Zoom, could I just talk to him for a second?
Yeah, yeah. I mean, yeah. Not a problem. All right, Mr. Wells, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Nathaniel Wells. This is file number 21-20376 FH. This is a date and time set for sentencing in this matter. Miss Underwood, you represent Mr. Wells, and did you say you needed a moment to speak with them?
I do, Your Honor. Thank you.
All right, so Mr. Wells, I'm going to open up a breakout room. And I'm going to assign you and Miss Underwood to that breakout room. So you'll get an invitation. Hold on, let's see, you're in jail Zoom 1. Hold on. So jail Zoom 1 and Miss Underwood. All right, you should get an invitation to join. Go ahead and join that breakout room.
Judge,
Yes.
I'm covering Tom and I have to jump over to Old Saver for a second.
Okay, are you on, and you're not on for now?
No, I'm not on
Okay.
for now, but I will be on Wells and Schumacher.
Who's on for now? Oh, well, anyway, go ahead.
Well, I'll check and see who's on for now and I'll be right back, okay?
Okay, thank you.
Yeah.
Right, I'm gonna close that breakout room. And bring Mr. Wells back. All right, Mr. Wells and Miss Underwood. All right, and this is, I don't know who drafted the PSI because it is Sarah's. All right, so Mr. Wells, have you had an opportunity now to review the probation violation report with your attorney?
Yes, ma'am.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yep.
Miss Underwood, do you wish to explain or challenge any of the information or accuracy of the information in the probation violation report?
We do not, Your Honor.
Right? Miss Underwood, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Mr. Wells has struggled with both mental health and substance abuse issues, Your Honor. He, I think, those issues are always difficult for self-motivation to get help, Your Honor. I think the probation department has done a good job trying to get Mr. Wells help, and I think he needs more, Your Honor. I would very much ask that the court place Mr. Wells back on probation and try to get him the rehabilitation and mental health services. I think with perhaps more supervision, such as a tether or something, Mr. Wells is motivated to address these issues. Thank you, Your Honor.
Mr. Wells, is there anything you'd like to say on your own behalf?
No, ma'am.
So, Mr. Wells, when we initially sentenced you on the underlying offense back in June of 2024, I deferred a 1-year jail term, and the recommendation is for you to complete that jail term. So it is the sentence of the court that you will serve 1 year in the Lenawee County Jail. I will give you credit for 185 days already served. And
Your Honor,
I believe,
I'm sorry. Is that credit correct? That was, I believe, like a week or so ago. I don't.
okay. We'll
That was,
double,
she was made on the 18th or whatever, and that was 185 days then is what she was trying to say. So that was like almost a week ago.
all right, let me check. Following violation of probation hearing. So, I don't know, whatever it is, we'll check with the jail and make sure you get the right credit. So we'll double, Miss Adams will call the jail and double check that, and I'll get Miss Teskey back in a moment. So we'll give you whatever credit you're obviously entitled to. Your probation is continued, and I think there is a contempt of court, and I'm going to dismiss that, all right? Mr. Wells, you do have the right to appeal this sentence, and they're going to give to you 3 copies of your notice of right to appellate review, initial and date, 1 copy for our records, the other 2 are for you. If you wish to appeal your sentence, you would fill out the information on the form within 42 days. Mr. Wells, when you get out, your probation is going to be continued, and we're going to continue to offer you those programming, but understand your guidelines allow me to send you to the RAP program or even to prison. Do you understand? Okay, you're all set, Mr. Wells. Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you, Miss Underwood. You hearing Nathaniel Wells?
Reese.
Huh? No, but, okay.
I was not, seriously, that was Tom Morris. Let me go get the file.
She did the original PSI, but we need to just find out what his credit is.
Oh, okay.
I think he's got a week more than what it said, but thank you. Glad about that. I was hoping he had Michael. I was hoping he had Michael.
I didn't see you in office.
I'm just late, I haven't gotten to.
But you know what? I didn't even notice it on the.
Oh, really?
I didn't.
You know, it just grows back so quick. I
Yeah.
shave in the morning, at night, it's back.
Yeah.
So I said, you know, why do you do it?
Right, yeah. Looks good.
How did it go?
What's that?
How is it, can I?
Oh, yeah, yeah.
I got my God.
What? No. Did you hear?
I had taken it off, but, and so they sent it off to the lab.
Yeah.
Biopsies or whatever, and
Uh-huh.
so it said, she got it out Tuesday, and they said 5 to 7 business days.
Were they knowing?
And so
How
it-
many did they take? How many? 3?
big cuts too.
Really?
Yeah, she's a true, she doesn't complain about it.
Right.
They had surgery Tuesday. She was wincing and whining and crying. I know, it was hard
Oh,
for her. I
it
know.
does.
It was
hurt you.
tough, yeah.
Well, and Major, that's weird. Doug brushes him every week, and he found a couple lumps, one on his chest,
Mhm.
one underneath his, I think, front right, or leg.
Yeah.
And so we took him right away to the vet. She said, you know, they could just be the thing, you know, just watch it. If you see that it changes with the throat, then you're here again. So,
Well, and that's what they said about,
yeah.
but it's like, it's hard to, I mean, I try to monitor it as
Right,
best I
of
can,
course,
but
of
it's,
course.
you know, it's hard to, I mean, obviously, it's
Right,
soup, but it's,
right.
but like mine growths, it's hard. to-
Right.
So so I take her to a vet,
Uh-huh.
and then I took her to like a clinic, like
Yes,
a, you know,
yes.
like an hospital clinic. And then, and she had one on her mammary gland, and then one on her leg, and then one on her back.
Oh.
And so I told them, I said, you know, I suspect that she's part of a puppy mill, she's
Right.
giving birth to multiple litters, and blah, blah, blah. She's about 4.5. So the guy said, you know, look,
But it
the
sounds
one on
bad.
the mammary gland,
What was the credit on Mr. Wells?
and she,
I don't know what.
Well, I wish you the
Thanks, Sarah. You're welcome.
So, you can be seated. What was the credit on Mr. Wells?
She said it was right, what Mr. Moore has.
All right, so we'll check with the jail just to double check it. He thought it got adjourned a week, I think.
Oh.
On
No,
4/14,
no, yeah, and I just did day calculator on that, and he's actually come up with a day less, so. When I figured out, it's 12 days, the time got 13.
Okay, we'll double check. Okay, so I have, Ms. Schumacher.
Aye.
Okay, and who's your attorney, Mr. Malaro?
correct.
Okay, he's next door, Judge Olsaver, so we'll be with you in a minute. And then I have another gentleman from the jail. What is your name?
Corey Reese.
All right, so Mr. Reese. I find you. All right, Mr. Reese, this is, let me see who your attorney is. Mr. Murphy, I don't have Mr. Murphy either. So, all right, so Mr. Reese and Ms. Schumacher, it will just be a moment. And let me see if I can get. Here's Michael. There Michael's.
hello.
Hey, this is Judge Anzalone again. I'm sorry. Brandon Farnell, that's yours, right, Mr. Dagmar? I have 3 jail windows open. I don't know if I can get him too, because I just lost the attorneys for the other 2.
Yep, I will get him.
All right, thank you.
Bye-bye.
Bye. You can text Matt or Sam and say, Judge has got your people, they're just waiting.
I'll say I'm just the messenger. Judge, should I log on to Zoom
You can,
for the, I'll go.
yeah, Scott Baker's back there, if that's okay.
Oh, sure.
But maybe I'll let him back. All right, Mr. Farnell, bear with us just a moment. Mr. Dagger Margosian is going to log in to chat with you. So as soon as he logs in. This is in the matter of the people of the state of Michigan versus Brandon Charles Farnell, file number 2024-21673FH. I have Michael Dagger Margosian appearing on behalf of Mr. Farnell. And Mr. Farnell, the last time we were here, you had asked to be brought in person for sentencing. I apologize that that didn't happen today. I think it was just some miscommunication. We have a couple options. You can agree to be sentenced today via Zoom, or I can set it up having you brought over sometime today. So Mr. Farnell, are you okay proceeding this way, or are you going to ask to be brought over?
I don't know. Can I just talk to my lawyer for a minute, ma'am?
Of course, of course. So I'm going to open up a breakout room. Mr. Post, before I put them in a breakout room, is there any information you wanted Mr. Dagger Margosian and Mr. Farnell to have?
Judge, we do have the contempt of court for his positive drug test. He has been in jail on that violation for district court, where he was actually kicked out of their ET program. So with him serving 90 days on that, my suggestion on the contempt is just to dismiss it.
Okay, so thank you. All right, so I'm going to open the breakout room, and Mr. Dagger Margosian and Mr. Farnell, you should receive an invitation to join the breakout room. All right, so. Where'd Mr. Dagmar go? He's come back up. So. Now you're gonna make me start counting now too. So we are back on the record in the matter of the people of the state of Michigan versus Brandon Farnell. Mr. Dagmar, have you had an opportunity to speak with their client?
Your Honor, I have, thank you for the time. I've gone over the PSI with Mr. Farnell. There are no additions, corrections, or deletions to be made. We already proceeded with sentencing. As this is a misdemeanor, of course, guidelines don't apply. What I would propose to the court is that, I guess, some information on Mr. Farnell, as indicated in PSI.
Can we first ask if he's willing to waive being present in
Yes.
person?
Yes, thank
So,
you.
Mr. Farnell, are you willing? I know you had requested to be in person, and I apologize again that you were not brought over. Are you willing to proceed today via Zoom?
Yes, ma'am.
All right, thank you, Mr. Farnell. All right, go ahead. Mr. Dagmar.
Thank you. Your Honor, as indicated in the PSI, Mr. Farnell was in the district court ET program. Unfortunately, that did not work out. He has been violated probation on that case, has been revoked. He has been sentenced to, on belief and information, to 93 days in jail minus whatever credit he already has on that case. I would ask this court to impose a similar sentence on this. His out date on that case is approximately May 16th. There is an indication in the PSI that he has about 50 days of credit on this case. I can't confirm that at this time, but obviously the court will confirm that. But my request would be, because he's serving a jail sentence on the misdemeanor case, I don't suspect that probation would be all that helpful in this case. And so I would ask the court to just allow Mr. Farnell to hit the reset button. And he is remorseful for this. And he just wants to better himself next time and move forward. So I would ask the court to impose that jail sentence.
All right. Mr. Farnell, is there anything you want to say in your own behalf?
Yes, ma'am. I had overdosed and had to get an ambulance ride to the hospital, went to the psychiatric ward. When I got out, I went and talked to Miss Gibson. I was in a kind of toxic situation. I continued my drug use. When I went in, what Mr. Cost had mentioned, when I went in and I failed my UA, I knew I was dirty. I went in and talked to her and I explained to her what was going on and that I needed treatment. And so I continued out there, obviously not doing very well. I had heard that I had a warrant, so I came to the courthouse and I sent a lady in with my money to pay my fines, and I called Miss Gibson and explained to her, I found out I had a warrant. I was scared to go to jail. She transferred me to Mr. Cost. I talked to him trying to get this figured out. And I'm just saying all that to say this, like I wasn't trying to run. Yes, I was scared to turn myself in, but I was still, I had called, got a referral and an assessment done to get into treatment. Like I wasn't trying to continue the path I was going at all. I was in a real bad state of mind. And I just was trying to let you know that I wasn't out there trying to continue this lifestyle. Like I was trying to help myself. And the only thing that stopped me from going into the courthouse was I heard I had a warrant. I was just scared of going to jail. That I was still paying my fine. I was trying to do what I was supposed to do, trying to get into treatment. And I eventually got picked up the day after I paid my fines, which kept me from getting into treatment and everything. But since being in here, I've talked to Christy about getting into treatment at transitional house. Like if I do get this sentence and am able to get out the 16th, like I will be going to treatment soon after being released. But that's all I wanted to let you know, ma'am.
Okay. Anything else, Mr. Dagomar?
Thanks.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law and protection of society. Mr. Farnell, as you heard earlier, we will dismiss the contempt of court. Sentence to the court, you will serve 7 months in Lenawee County Jail. What do you think your credit is, Mr. Farnell?
Somewhere around 50 days, ma'am. I'm not for
Right.
sure at this point.
All right, I'll give you credit for 50 days already served. We'll verify with the jail if that's the correct amount as well, that I don't have it in the report. And there will be no probation. There is a $75 crime victim rights fee and a $50 state cost. Mr. Farnell, you do have the right to appeal this sentence. We're going to send over to the jail 3 copies of your notice of right to appellate review. They'll have you initial and date 1 copy for our records. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Farnell, I work with Christy quite closely. So if a bed is found for you in an inpatient rehab program, she can always speak to me about an early release, okay?
Yes, ma'am.
All right, Mr. Farnell, I wish you the best of luck. Thank you.
Thank you.
Yeah.
Thanks, Mr. So, Mr. Murphy, you have.
Mr. Reese, could I have a breakout with him, please?
Yep. So in the matter of the people of the state of Michigan versus Corey Allen Reese, file number 23-21459FH. I have Matthew Murphy appearing on behalf of Mr. Reese. And I'm going to put you both into a breakout room. And your jail is 1. All right, there you go.
Thank you.
So in the matter of the people of the state of Michigan versus Tiffany Renee Schermacher, file number 23-21338FH. I have Salvatore Malaro appearing on behalf of Ms. Schermacher, and I have Allison Arnold appearing on behalf of the people. This is the date and time set for sentencing. Mr. Malaro, have you had an opportunity to review the pre-sentence report with your attorney or with your client?
I have not, Judge. Could I have a quick breakout, please?
Yep. So Ms. Schumacher, I am going to assign you and Mr. Malaro to a breakout room. We're in 1. All right, you should have got an invitation to join. Thank you. Is there a TG Cook in the courtroom? Cook? Has anybody showed up on your case?
No, Your Honor.
All right, I'll take care of it for you.
Sure.
This is in the matter of Daniel J. Hartley versus TG Cook, file number 23-7145 CK. I have Scott Baker appearing on behalf of plaintiff. This is the date and time scheduled for a final status conference. Mr. Baker is here on behalf of the plaintiff. It appears no one has appeared on behalf of the defendant. I do show on October 23rd of 2023, an answer was filed by TG Cook. And I ordered facilitation with Mr. Godfrey. Did they appear at that?
Judge, we were unable to, we didn't get facilitation scheduled yet. I was gonna come in today and ask you to push this out, maybe 120 days, push the dates out. It's a little, just becomes a little more cumbersome when they're pro per.
That's fine,
And Mr.
that's
Cook
fine.
is pro per,
So they've had contact with you.
not since filing the answer.
Okay,
Now,
so,
we did have, like you mentioned, I think they appeared via Zoom. Mr. Cook appeared via Zoom on December 11th, 2023, when he
Right.
conducted the original pre-trial, but I've not had any contact since.
okay, so Miss Adams, I'm looking for a settlement conference. Maybe September 1. Or maybe the September 6th or 13th.
September 6th is good.
Is that good for you, Mr. Baker?
Yes, sir.
So we'll set this over to September 6th at 9 a.m. Miss Adams, because the parties are pro per, and I'd rather a notice be sent from.
And Judge, just so I'm clear, are we able to extend these dates? Your original scheduling dates, trying to, in other words.
Are you
try to-
making a motion to extend the
Yes.
scheduling order
Yes, I
dates?
am.
Would you like them all extended? All right, so Miss Adams, I'm probably gonna do a scheduling order as well now. All right, so discovery originally was to be completed by March of this year. Are you asking for discovery to be extended?
Yes, Judge, maybe till like July.
About July 22nd? And let's see, and then expert witness lists, maybe,
We can have all our witnesses exchanged by, let's say, May 1st for both
Okay.
of us.
all right, and how about May 17th for them?
Yep.
Okay. Oh, let's see, I had dispositive motions must be filed and heard by April 26th.
You want to just make that the November, or excuse me, the September 6th date to coincide with our,
That's fine, and then,
and we can still try to get this facilitated with Mr. Godfrey. I know he's scheduling out into September now, but we can at least provide you with an update that September 6th.
Okay.
Thank you, Your Honor. Have a nice weekend.
you too. So Ms. Adams, I did a scheduling order on that one. So, okay. All right, Mr. Reese.
Hello,
We're
Your
back
Honor.
on the record. Yep, we are back on the record in the matter of the people of the state of Michigan versus Corey Allen Reese. File number 23-21459FH. I have Allison Arnold sitting in my courtroom on behalf of the people. And then I have Mr. Murphy appearing on behalf of Mr. Reese. This is a date time set for sentencing. Mr. Murphy, have you now had an opportunity to read and review the pre-sentence report with him?
Yes, Your Honor, I just wanted to place on the record that I believe we weren't aware that he was still in custody, I think, because we mailed a PSI to his out of custody address, the last one that we had. So we hadn't before today received a copy, but I have reviewed it with him. I just wanted to make sure the court was clear with that record. And Mr. Reese, are you okay with continuing with the sentencing today without actually having a physical copy and reviewing it physically there?
Yes, I am.
Okay. Your Honor, again, we have reviewed the pre-sentence investigation report. There were no additions or corrections or issues
All
with
right,
the
so
information.
let me go through my little spiel, Mr. Murphy, so I don't forget anything. Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
Your Honor, the only accuracy issue that we have is that Mr. Reese does have a 1.5 years of college education that isn't reported there. He wanted to make sure the court was aware of that. I don't believe he has a completed degree yet, but he does have a 1.5 years of college credits.
Okay, so we'll make note of that. We've not any verification of it, but we'll make note of that. Anything else, Mr. Murphy?
Nothing in regards to accuracy or relevancy, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
The probation officer in this case has computed the minimum sentencing guidelines to be 7 to 46. Mr. Murphy, I reviewed the guidelines on PRV 1. It was scored at 50. And Ms. Holly, I only saw one high severity felony conviction. Okay. I saw charges, obviously, but I didn't see any other high severity convictions. The only one I saw was
third degree.
which number?
Number 21.
Let me get there. Let me get there.
Well, I can't even remember what numbers this high severity.
So I know he had a burglary larceny, which he was convicted of, which was a felony 3rd degree. So I did list that one as a high severity. That was number 11 of 30. It was out of Palatka, Florida. And then I had unarmed, well, there was number 13. We don't have any information on that one, so we don't know if that was conviction or not. And then I had let me see. A lot. Got a home invasion that was pled down to a person E offense, so that's low severity. That was number 21 of 30. And then, because it was an E grid. And then he has a pending one, but I only showed the one high. It doesn't change the guidelines, Mr. Murphy, but it does take that one down to.
Probably was counting the one in Florida, the felony 3rd degree.
Right, which I think is a low severity in Michigan.
Thank you, Your Honor. I was going to raise that issue again without it not changing the guidelines ultimately, but I was questioning that before, what Your Honor did before I did.
It doesn't change guidelines, it just.
So what number?
So PRVs would be 87. If we change PRV 1 to 25, but the guidelines still stayed 7 to 46.
Okay.
Okay, doesn't change them. So were there any other ones, Mr. Murphy? I didn't see any other ones.
No, that was just that one, Your Honor. And again, I would agree that it didn't change the guidelines ultimately. guideline range.
So you agree with the computation guidelines then?
Yes, 7 to 46, Your Honor, yes.
All right, so before the court passes sentence, is there anything you'd like to say on behalf of Mr. Reese?
Your Honor, in regards to the matter, well, Mr. Reese deeply apologizes for the situations that have happened here. If you look at the situation at McDonald's, the whole it's kind of confusing. He was there with a friend, if you want to call it. I'm not quite sure the relationship, how it's actually is, but they were there trying to warm up, and obviously the manager said they had to leave, and there was some argument. I don't believe Mr. Reese did anything with the bat. A caller called in and suggested there was something going on, but Mr. Reese never did anything. I don't believe he was ever trying to do anything. He does apologize for that situation and what occurred from there. And in regards to the fleeing and the incident that was the alleged indecent exposure, that was a confusing case, because at the body cam, when I watched the body cam and at the preliminary examination, the officers, it was confusing as if I don't think they ever said police stop or anything. They just chased Mr. Reese, and Mr. Reese knew that he had a warrant, and so he knew he shouldn't have ran. But again, whether the police actually acted appropriately was in question as well. But again, Mr. Reese, he understood that he knew he had a warrant, so he should have accepted that he was going to be taken into custody on that warrant. Either way, he does apologize to the court for what's occurred. He does apologize for being here and taking up the court's time. He has, I believe, 317 days credit, if I got that correct, on these cases. He does have a pending situation, a pending felony case in Jackson. He will be in custody there after being released here. Excuse me. So I would ask the court to consider giving him credit for time that he served on these files and closing them out and allowing him to then go to Jackson and do whatever is going to happen in Jackson. I know the recommendations for 3 years probation. I understand that, obviously if Mr. Reese wasn't looking at something happening in Jackson and wasn't looking at, the time he already has served for these files, I believe probation would be appropriate. But given the situation, again, given he's served almost a year on these files, given the guideline range, and given that he's going to go to Jackson, have a situation to deal with in Jackson, I would ask the court to consider that. Obviously, if he's on probation, he will abide by probation when when he gets out of whatever is going to happen with Jackson. If he's released from custody or whatever, we will make sure he abides by probation. But I think that the best situation in regards to judicial resources and everything, maybe just to give him credit for time served.
Okay, Mr. Reese, anything you want to say on your own behalf?
Yeah, I know I look bad on paper, but I'm sorry for all this. And he's right. The first RNO, I was trying to help a homeless woman get food and shelter. So, and I ran because I knew I had warrants. I panicked. I'm sorry for that. I wish I wouldn't have ran. But that's all. Thank you.
All right, thank you. So Ms. Holly, Mr. Reese has obviously the drug felony case in Jackson County, a contempt of court for failure to appear, as well as there's an RNO in Jackson County. What is your position on probation?
I have no objection to whatever the court decides.
Okay, I know it's not your file, but do you have any position?
No, thank you.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of the law, and the protection of society. Sentence of the court that you will serve 317 days in Lenawee County Jail. We'll give you credit for 317 days. I'm not going to place you on probation. I'll let Jackson County deal with you. There is a $130 crime victim rights fee and $68 in state costs. And Mr. Reese, no one is always innocent and gets in trouble with the police. I'm sorry. it just isn't possible. So I think methamphetamine use might mean you don't quite remember the situations that occur, but I wish you the best of luck in Jackson County. Now, you do have the right to appeal this sentence. My bailiff's going to hand you the jail is going to give to you 3 copies of your notice of right to appellate review. I'll have you sign 1 copy for our records. The other copies are for your records. If you wish to appeal your sentence, you would fill out the information on the form, mail it to the address on the form within 42 days. All right?
Yes, ma'am.
All right, thank you. You're all
Have a
set.
good-
Thank you, Your Honor. Thank you, Mr. Reese. You have a good day, okay? Take it easy.
Thanks, Mr. Murphy.
Thank you, Judge.
Thank you, Your
Thank
Honor.
you,
Have
Ms.
a good
Allen.
weekend, everybody.
You too, thanks. All right, Mr. Malaro, let me see. All right, so whoever is in the jail Zoom, I'm gonna send you a request to unmute and to start your video. I think it's Ms. Schumacher, so I don't know what happened. Oh, there you are. All right, Ms. Schumacher, and Mr. Malaro. This is in the matter of the people of the state of Michigan versus Tiffany Renee Schumacher, file number 23-21338FH. I have Salvatore Malaro appearing on behalf of Ms. Schumacher, and I have Allison Arnold appearing on behalf of the people. Mr. Malaro, have you now had an opportunity to review the pre-sentence report with your client?
Yes, I have, Your Honor.
All right, Ms. Schumacher, you've had an opportunity to read through it and review it with Mr. Malaro? Can you, all right, so we're not getting really good audio on you, so if you can kind of sit forward and speak louder, it's the room you're in, it's not your fault, I apologize. Okay, have you had a chance to read and review it with your attorney? No, we're still not getting audio. And it's just the room and maybe you're too far back.
Is that better?
That's better, and just speak loudly. So now you have had an opportunity to read and review it.
Yes, Your Honor.
Good. And are you, you've had time to ask Mr. Malaro questions and discuss it with him?
Yes.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, what I would say is Miss Arnold had filed a sentencing memorandum addressing a couple of OBs. We have no objection
Hold
to
on,
those.
hold on. Miss Adams, did we get a sentencing memorandum? I'm sure we got it. I just didn't get it.
Filed a couple, like 3 weeks ago, 2 weeks ago.
It's not in the file.
Looking, Judge.
I'm sorry, I don't have it. I'm sure it was sent over and I just.
Want to right now.
Okay,
Judge, I have a copy readily available. I can bring it over.
okay, thank you.
Yep.
I'm sorry,
No, you're good.
just didn't make it in my file. Okay, so, all right, so I've got it. All right, so Mr. Malaro, I reviewed this. And doesn't happen often, but Ms. Arnold is asking that some of the OVs and PRVs be scored lower. So let's hold on one second. So Mr. Malaro, other than the guidelines though, you don't wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence, right?
Well.
And then I'm gonna go to Ms. Arnold and she can talk about the information she wants included.
Only as to the restitution, I think the rest, is, other than the scoring, we have no objection to. But I think the restitution probably be argued it, but I think we're in agreement on the restitution. But that would be the only issue we'd argue.
Not to jump in, but this might make things quicker. There's probation put a figure of $13,995 in restitution. And I'm not sure where they got that figure from. Mr. Malaro brought that to my attention this morning, and I'm not sure if Ms. Tusky can illuminate where they got that figure from. That might help resolve the issue.
I could speak to that.
Okay,
the figure
so
comes from the state police. But the amount, there's only two numbers that are attributable to Miss Schermacher, and one of them, I believe, is out of Jackson County, so it wouldn't even apply to our county. And so I think as I look at it, we're only looking at $900.
So Ms. Arnold, I can assess restitution from Jackson County, but do you agree? What do you believe the restitution amount is?
So the two charged offenses here, well, there's only one charged offense here that involves a buy. And actually the Jackson County $800 was recovered. So I guess I'd like to look at that document from the state police. No one sent me a copy of that. If I could look at that, but I believe restitution is only 900. But I'd like to take a look at that document.
So Ms. Teskey, can you perhaps enlighten us on the information you received?
Yes, I received an email from Mark Moore that I can forward to anybody that wants it.
Okay, if it could be forwarded.
Yeah, could you send that to Mr. Malaro and Ms. Arnold?
Yeah, I already sent it to Malaro.
I already have it, Judge.
So it is not the 14,000?
I have not seen that email. This is the culmination of an investigation that goes back to 2021 involving numerous narcotics transactions.
I just forwarded the email to Judge and Allison Arnold.
Thank you, Ms. Husky.
Our firewall delays everything.
I don't know if we can talk about other stuff and then go back to that maybe. Oh, I've got it now.
Okay.
Yeah, I think the other there's only two figures here that are listed relating to Ms. Schermacher. What I would ask the court to do is just order restitution in the amount of $900 for now. And I would like to have the court reserve ruling on the rest of it, and I'll speak to Rhino to see if any of this is attributable to Ms. Schermacher. But if we can order 900 now with the thought that we can reopen it if we're seeking more, I would ask the court to do that.
Mr. Malaro?
Yeah, I would be opposed to that, Judge. This other person named Hill is not mentioned as a co-defendant in this case, or any of the cases that I see. And I also don't recall this person being in any of the police reports. Seems to me it's out of Jackson. And since she has charges pending in Jackson, I think it'd
Okay,
be
so,
up to Jackson to do.
okay, so here's what I'm gonna do. I'm going to adjourn this just so that Ms. Arnold can reach out to them if you're gonna object. And then you can reach out to them and, we'll see where we go from there. So I can get another date, like a week out or something. And then we can, obviously, Ms. Teskey has your memo. She can correct the guidelines. Not that they're wrong, but correct them in terms of our agreement.
So Judge, I'm changing the guidelines according to the memo that Ms. Arnold wrote. There are no
let's go through
guidelines
that
that are
real quick.
staying the same.
Hold on a second. So, we have, number 5 in Ms. Arnold's, so Mr. Malaro, Ms. Arnold stating that OB 12 should be scored as 0. Would you agree with that?
Yes, I would agree with that too.
You have accordingly, no point should be assessed for OB 12.
Okay, sorry.
Yep, it says, it's scored as a leader. And then Ms. Arnold, because we did sit down and go through the guidelines together in the back and come up with the guidelines. So then, okay, then, what were you going, so Ms. Arnold, I have a 10 leader points under offense variable 14 and 5 contemporaneous points under OB 12 are not assessed. The Cobb's evaluation would be within guidelines. If the leader points or contemporaneous acts points are assessed, Cobb's evaluation would be below the guidelines. So is there another OB?
I think it was 5 and
So
12.
here's the thing on leader points. It's our position that Ms. Schiermacher was a leader in the greater operation, and that was part of what we told the court, that the court considered for the Cobb's evaluation. And part of my argument today was going to be, this goes back to 2021, and the reports, Mr. Hill's name is actually mentioned numerous times in the reports because Ms. Schiermacher, when she's in jail, directs him to continue her operations. But in terms of the particular offenses for which she's being sentenced, there's one where she's found with narcotics in her possession. No one else was involved in that. And then the particular undercover sale that takes place that's not actually in the PSI, which needs to be added from March 13th of 2023. She alone does that delivery, and there's no indication that anyone else is involved in that particular delivery. So I think there's an argument that could be made for leader points. I did not score them, but I think there's an argument that could be made for them.
So are we, that's OB 12. No.
That's OB 14.
OB 14. So I guess my question is, Ms. Arnold, are you asking for it to be scored or not to be scored?
I guess we would defer to the court. I did not score it. I think it could be argued either way.
Okay, all right. So I'm going to get another sentencing date. Ms. Adams,
Yes, Judge.
I just need another date for sentencing, maybe a week or 2 out.
I'm not here in 2 weeks, but I am here next week.
Maybe next week.
Judge, next Friday you have like 12 sentencings and you're not available Thursday.
Okay.
Unless you want to put it on
Can I
Wednesday.
see the book?
Maybe.
Can I see the book? Okay. Maybe I can. So Friday, we have a ton of sentencings, but I could do 11 o'clock on next Friday, May 3rd.
That works for me.
Mr. Malaro, would you be available Friday, May 3rd at 11?
Yes.
All right, and Mr. Malaro, if you can get a response to her motion and or her brief sentencing memorandum, that'll help, and then we'll see you back on that day then. All right. All right, Ms. Schumacher, we'll see you back then. Thank you.
Thank you, Judge.
Thank you.
Judge, I'm going to, they're screaming for me in district court, so I'm gonna go.
I think I'm done. I don't have any more sentencing, so you're all set, Mr. Malaro.
Did you do Wallace, Your Honor?
I did. I gave him 1 year in jail.
Okay.
Dismissed the contempt of court.
Okay.
Gave him credit for 185 days and continued his probation.
Okay, thank you.
Thank you.
And Sarah, I think we're still waiting on verification of the credit. I don't know if you know it.
All right. The credit was as if Mr. Moore figured.
Well, we thought we adjourned it a week is why we thought.
No, the report that he wrote was as of 4/26, and that's today's date.
Okay.
So the credit should be correct.
All right, thank you.
Thanks, Sarah.
Have a good weekend.
Thank you.
I will.
Every day in the USA, people find themselves in court.
Good afternoon. We're back for a fairly brief landlord-tenant afternoon. I'll start in a minute. We have a couple. I think one's been dismissed. This morning I was talking about Russian crime novels. I don't know if anybody's interested in that. I read a lot of crime novels, but I mentioned Stuart Kaminsky for the character Inspector Rusnikov. One of those books won the Edgar Award. It's called The Fine Cold Red Sunrise. That was a very good book. I mentioned Martin Cruz Smith, who wrote Gorky Park and a number of others. His characters are Katie Rinko. One of those won the Edgar Award. And an author I really like named Sam Eastland wrote a character called Pekala. And it goes all the way from the time of Tsar Nicholas through the time of Stalin. A lot of Russian history and very interesting. A couple other authors, William Ryan, Gerald Brown. And there were even some Tom Clancy novels set in Russia. Anyway, I read lots of that kind of stuff, but those are very good. If anybody's interested in those, I'd start with the Cold Red Sunrise. And maybe Archive 17 by Sam Eastland. That's not his real name, but he writes as Sam Eastland. Anyway, I never did book reviews before, but there's some other authors I like, lots of them, but those are the Russian ones. Writing Russian characters anyway. So thank you for saying hello. And I'm sure it's beautiful in California and Canada and Waterboro and Gorky Park. I'll give you some other Rex. Anybody cares? All right, let's get started. There's people here. Thank you for saying good afternoon to everybody. Makes me want to read the Inspector Rosnikoff books over again. As I mentioned, Stuart Comiskey also wrote 6 books at Siesta Key. And I enjoyed those. I'm sorry he's passed away because I don't get to see how all the books turn out. You get to be attached to the characters. Wish them all well. Let's see what we got here. Let's turn a record on. A Cold Red Sunrise.
Afternoon, Your Honor.
Good afternoon. I think you've got my first 3 cases this afternoon. One of them has been dismissed, so.
Yes, right. The middle one.
Yeah, so we got dead time in the middle. Good afternoon. You're logged in as Ronald Hart, or you're logged in as Moto. Which case are you here on? What's your name? Ma'am, can you hear me?
Oh, yes, I can hear you, sir. I'm
What's your
Cheyenne
name?
Woods.
What's your name?
Cheyenne Woods.
All right, you're here for a second case. Well, good. That'll speed us up. Could you take your gum out, please?
Yes, I can.
Thanks for coming in early. CHYANN. All right, our first case at 115, and it is 115, is Ronald Hart. He was personally served, but our 135 case, the last one in line, Cheyenne Woods is here with us. So we'll go ahead and start with that one. This is 24555LT. It's entitled Deer Creek Townhomes versus Cheyenne Woods, which means so far we've had at least 555 landlord-tenant cases filed. You're logged in as Lynn. Are you the manager at Deer Creek or are you at Cato?
I'm
Cato.
All right, well, we'll go ahead and start this one. I didn't know if you did more than one. This is filed as a demand for non-payment of rent. Ms. Woods, if you are a defendant in such a case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And Meg Bauer from Legal Aid is about to join us on the feed. and you can contact them. I sent you that information with the information you got, but she'll be here in just a moment. You have a right to have the matter heard here in St. Joseph County where the property is. You have the right to demand a jury trial. That never happens, but if you do, you have to do it at this hearing or file a written demand for a jury within 5 days, and pay the $50 jury demand fee. If you can't afford the fee, you can ask the judge for a waiver, and we can either provide you with that form or tell you where to find it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, the local coordinated agency, a housing assessment and resource agency in our county that is called Neighborhood Inc., or a homeless veterans program if you're eligible for veterans benefits. And we did send you that information also. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint for your case are sufficient. Mr. Bradshaw, we've had a recent run of people that tell us DHS told us we couldn't get any assistance until we get a judgment. And I don't know if you've been seeing that also, but
Well, we've been hearing that for years and it's.
yes, likewise.
Everybody knows that it's not true.
Yes, but that's what the poor people are being told. So we give them a judgment and then hopefully they can get some help. You may be able to reach an agreement with your landlord by going through a local community dispute resolution agency like ours. It's called the Citizens Mediation Inc. If both parties are interested, we can make that referral. If you are able to reach an agreement with the landlord that the case gets dismissed, the court must provide you with that form called a conditional order of dismissal form, or tell you where to find it. So let's talk about this case. Your rent is $758 per month, according to the pleading. And Mr. Bradshaw, what's the current status?
So, Your Honor, Ms. Woods has actually been doing a really great job this month, the month of April. She's made several payments. And frankly, where we are today is, even including the court costs, she only owes $133.30. She's made over $2,000 in payments since in three or four payments since the beginning of the month. So we're only at $133.30 through the month of April. I'm more than happy, and in fact, I've already prepared a conditional dismissal. If she can get the remaining balance taken care of in the next 10 days, I'm more than happy to enter that. Of course, this does not include May because we're not in May yet. You know it's coming up, but here's where we are for the month of April and this particular case right now.
All right, if you pay $133 plus $758 for May, let's add that up. $891. That's not right. $758 plus $133 is not $891. They would dismiss the case. 10 days from today is May the 6th. That's a Monday. Do you think you'll be able to do that?
I believe so.
Well, you know, Your
Well,
Honor,
let me tell you.
please support. You know, since you're going to include May in this, I'm more than happy to do that. Which in my mind, I'm thinking ahead that we'd have another hearing.
Yes.
If you're willing to get this taken care of by, like, say, the 15th, and I'll include May, then that would be. Is that something you could do, ma'am?
Yes.
Okay.
All right, because what would happen, the law requires that I adjourn this at least 7 days. Unless we work something out like this, which would take us to May 10th. Excuse me, May 3rd. And then you'd get another 10 days from May 3rd to move or be subject to being evicted. So Mr. Bradshaw's already wrapped those time frames into here. And this will save you from having to come back next week. So you would pay the balance of $133 plus May's rent by May 15th. And if you do that, they would show that the matter was dismissed. Is that agreeable with you?
Yes, sir. Can you hear me?
Yes. Now, does Mr. Bradshaw have your authority to indicate that, and it will indicate she consented on the record to those terms?
Yes.
Is that acceptable to you?
I'll sign your name, ma'am, and I'll submit it to you and to the court.
Okay.
All right, well, let me tell you some more things that you need to know. If you do move, you need to turn in your keys and provide your forwarding address in writing within 4 days of your moving. I don't think that's going to happen. If you pay the rent, then we just go and the case is dismissed. However, if you don't pay the rent by that date, you would be subject to the entry of a writ of eviction where the sheriff could come put your stuff out. And so it's important that you believe you can make these payments. Do you believe you can?
Yes, sir.
Well, you've done an excellent job, according to Mr. Bradshaw. You only owe $133 and May's rent is due anyway. What we've just done here saves you from coming back for 2 subsequent hearings. Now, he's going to send you this order. He's going to send it to me and I'm going to sign it. We're going to send it to you. If it doesn't match what we discussed here in court and you have any objection to it, you have 7 days to let the court know that. But if you pay, the case will get dismissed. If you don't pay, you could be subject to being evicted on or after May 15th. Do you have any questions?
No, sir.
This will show, it won't show on your credit record. It will show as the case being dismissed. All right, do you have any questions, Ms. Woods?
No, sir.
Thank you for being here early.
No problem.
And we've resolved that first case. Thank you. Tell Mr. Fleeman to hold it down over there. I can hear him in the background.
Well, he's not around. He's on the other side of the floor from me. It must be somebody else.
Oh, all right. Okay. All right. Well, let's talk about who isn't here, which is our first case, Mr. Hart. Let me check with the court officers and make sure he's not here in the building.
We anticipated he may not be here. The word is, and Lynn can confirm, he's been, folks, he's moving out.
Okay. Hello, Deputy Tyler. I'm looking for landlord tenant client Ronald Hart. Hart. All right. Thanks. Bye. We're going to lose some of our bailiffs. They've opened the court building in Three Rivers and shortly the probate and family courts are going to be in Three Rivers. They've opened a brand new courthouse on Michigan Avenue in Three Rivers. And so the family court cases and probate court cases will be held here, which removes about 30 plus cars from the parking lot. All the staff in those 2 departments will be going to Three Rivers. And Judge Tomlinson will be sitting in Three Rivers.
Oh.
The problem is our lawyers now have to be 2 places at once. They were always able to just come here, do a quick landlord tenant hearing, go up to Judge Tomlinson's case and hand a delinquency hearing or something, and then go to circuit court and perhaps work something out there. So you've had more than one courthouse. Well, one time you had 3 courthouses and when you had Portage.
Right.
But we don't have that many lawyers to go around. We're going to have to share them, and we may be doing some things by Zoom, but they've done a good job of refurbishing this old building, and it's not to my aesthetic style, but I won't be there, so I guess I don't need to worry about it. But sure be a lot of spaces in the parking lot.
So Michigan Avenue, I don't know Three Rivers that well.
It's right where McDonald's is. It's that road that goes down 131. The problem is coming to Three Rivers, now that they've reconstructed 131. You used to be able to get off on North Main Street. It's really hard to do that now, but that was a very dangerous intersection.
Where Frankie's is?
Yes, where Frankie's is. There have been a lot of fatal accidents at that intersection. Now, you can go to Michigan Avenue where the Admiral Station is and turn left, and the court is right there, half a mile down the street. So it's a nice bonus for Three Rivers. It puts that building back into service. It greatly improved it. It brings people to town for lunch and shopping and otherwise. It's not as convenient if you live in Sturgis or Colon or Burr Oak or somewhere on the other side of the county, but that's what they've done. And then when they finish that, they're going to do some refurbishing here in this building.
Rick and I drove by it the other day, and it obviously wasn't open yet, but maybe not obviously, but it looked nice from the outside. It was pretty easy to get to off the road. So that was, plenty of parking. That was nice.
It is pretty accessible. It's also a bonus for all the court employees that live in Three Rivers. But I've driven back and forth from my house to here for 44 years. I don't think my car could figure out how to get there. It's on automatic pilot, but I'll still be here for the next few years.
It's 5 miles,
Well,
right?
From my house to here is about 9. From the courthouse in Centerville to that courthouse is probably 7 or 8 miles. Well, let's call Cato Apartments Companies versus Ronald Hart. Mr. John Bradshaw is here on behalf of the plaintiff. Meg Bauer is here, and their manager, Lynn, is Furup?
Yes.
Is here on behalf of Cato. What's the status here, Mr. Bradshaw?
Yes, sir. This is summary proceedings for termination of the tenancy. The defendant was served a notice to quit. In terms of the procedure, the mailing procedure, we did do the request for the second mailing. And of course, we've done your request to do the postal mailing. The defendant does not appear to be here. I think if I put testimony on, it would the indication would be that Mr. Hart had been making plans to vacate the unit.
Is that true, Ms. Furup?
Yes.
And he's actually started moving?
Yes.
Well, let's just do a default.
I have a prepared judgment unless you have one.
No, I don't. If you'd send me one.
All right.
The date for the writ is 10 days from today, which would be May 6th.
That's what I've got.
Now, I didn't know the reason for the termination of tenancy. It just was a termination. Was this a just cause or just expiration of the lease?
Well, it's actually both. This lease has turned into a month-to-month, and there were many violations as well, and those were attached to the notice to quit. I don't know if we attach those to our complaint.
Well, I've got the notice to quit, but I don't have any.
You want to go in and you want to just give?
No, we don't need it. It's a default. He's not here and he's moving, and I guess I don't need to go on the record for what his reasons were, but we would have if we'd gotten into some contested issue. I'd ask you to email me the judgment.
Yep.
And then that leaves us one case. We've been here before. Elm Tree Apartments versus Cinquez Furlough. And it was a non-payment of rent case. And Mr. Bradshaw has provided a dismissal without prejudice, which I have signed. Ms. Furlough's not here. And this was set for 125. So if she was going to be here, she'd be here already. So that's all 3 of the Bradshaw cases today.
Thank you, Your Honor. Good to see you.
All right, you're good to go.
Okay, thank you.
Good to see you, Meg.
You too, John.
Meg, before I went on the record, I talked about some more Russian crime novels. I don't know if anybody's interested in that. We had a discussion this morning about
Thank you.
books I liked, so I talked about some more.
You sold me. I'll take it. I'm find crime novels far more interesting than
Well, my recommendation was you start with The Cold Red Sunrise. It's an Edgar Award-winning book. It's not the first book in that series, but if you like that kind of thing, you'd like that book. All right, we're gonna complete our afternoon a bit abruptly. There were several other cases that had been dismissed or otherwise resolved. We took care of everything this morning. We'll be back Monday morning with a civil docket, a criminal sentence docket, and a landlord-tenant docket in the afternoon. So I'll see you Monday. All right, thanks. All right, that completes our week. Good to be back from vacation. Good to have a weekend.
Has the back in Michigan Blues sunk in yet?
What's that?
Has the back in Michigan Blues sunk in yet?
Oh, I don't know, the sun has been out. It was, as I said, beautiful, beautiful there. And I only had a 4-day work week. I gotta be able to, but we've been busy. We went to that Supreme Court thing on Wednesday. But no, I guess it's time to get back to work.
How are the Supreme Court events? Are they interesting?
We did one here many years ago. This was interesting. They had a very interesting case. Now let's see who's here. I've got Dakota here. Which case are you here on? I think that might be just a passerby. Good morning, sir. Are you Michael Scott Warner? Can you hear me? I can't hear you. Could you speak up? Are you Michael Warner? All right. Got Mr. Warner in there, but the mic's not working. All right, thanks.
You hear us now?
Yes, I can. Thank you. There are several guys named Michael Warner. Further complicate things, there are Michael Warners Jr. and Sr., but you're Michael Scott Warner, that's correct?
Yes.
This is Judge Middleton. I'm here at the courthouse. Also present is Mr. Keith Stickley with us on the Zoom feed. He is the Chief Public Defender. You got charged with illegal entry in January, and this case has got a bit of a tortured history. Let me go in here. There it is. Thank you. Put in this in the queue. The complaint alleges that on or about January 12th, that you broke into a property that belonged to Alicia Klein out on Wilbur Road, and that you entered that property illegally. And so a warrant issued for your arrest, and you got booked in I think on March 6th. So we saw you on March 6th. There was an arraignment at the jail. And I gave you a $500 PR bond and set the matter for a pretrial. And you didn't show up for the pretrial on March 14th. So I did a show cause hearing to find out why you didn't show up for that. And you didn't show up for that. So a bench warrant issued for your arrest. Here we are. So the original charge, as I indicated, alleged that on or about January 12th, you entered this property on Wilbur Road without permission. It is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. You pled not guilty, as I indicated. I gave you a PR bond and then you didn't show up. So you got arrested last night. Now, in addition, you have another matter.
So
I think that may have been Judge Pattison, but the other matter.
Stuff. I've never used them, so I don't.
Was file one. In a methamphetamine case, there was a misdemeanor plea. And Judge Pattison gave you 20 days, credit 20 days, $475 fines or 4 additional days in jail. And I don't know that you ever made any payment. So that case is still hanging out. That's file 23907. There's some carryover from another room over there. How did you come to get arrested last night, Mr. Warner?
I was at my brother's house. And I don't know, cops just showed up or.
And where was that?
Right at 3 Rivers on Main Street.
Who's your brother?
Jacob Warner. He was at work at the time, so.
All right. Did you get charged with anything else, or they just picked you up on this old warrant?
Yeah, they just picked me up on the warrant. That was it.
Now, who is Alicia Klein to you? I thought she was related to you.
Yeah, she's my cousin.
All right. So let me repeat. The allegation is that you went into that property without permission back in January. You pled not guilty to that charge. Do you wish to continue your plea of not guilty?
Yeah, because I'm pretty. That was all taken care of already, because they didn't. I don't know. There wasn't nothing. I didn't think they wanted to go any further with anything though. So.
Well, the prosecutor charged it. Now,
okay.
Did your grandmother have some ownership interest in this?
I think so, yeah.
Yeah, you got evicted. And Bruce Morse came out and served the eviction, told you to leave. And then you came back in, according to this, went back in the house, made a bed, had some hamburger helper cooked on the stove. This was after I did an eviction case. So, yeah, they haven't dropped this charge. So, all right, I'll show your continued plea of not guilty. Keith, I had originally just I gave him a PR bond and set this for a pretrial with the prosecutor. And he paid me back by not showing up twice, first for the hearing and then for the show cause. Plus, he hasn't paid the $475 he owes on the last case. So I guess my options would be to set an attorney pretrial, but then it would get bumped all the way out to May 31st, or just set a pretrial with an attorney with the prosecutor. What's your thought here?
He probably would benefit from counsel, considering that what happened, and I'm sure he would. I'm sure he would like a reconsideration of a PR bond, and maybe having counsel appointed would help, or the court would consider a low cash bond. Either way, I'm sure he wants to deal with this, and will, I think, come back to court.
All right, Mr. Warner, do you want me to appoint a lawyer to help you with this?
Yeah, if you could, yeah.
All right.
You could be able to get.
Now, one option, I can transfer this to Judge Pattison. I'll set the attorney pretrial for May 17th. At 8:30. I think Judge Pattison may have had this at one point. Are you working someplace?
No, not right now.
When did you last work?
I'm not too sure when it was. It's been a while.
All right. Well, you had another case that was reduced to a misdemeanor. Judge Pattison gave you 20 days credit and a fine to pay, and you never paid anything on the fine. So that's going to need to be rectified. Then I let you out on a PR bond and you didn't show up. So I set a hearing to find out why you didn't show up, and you didn't show up for that. So you waited around to get arrested, and here we are. So I'm going to leave the bond. It was 500 PR. I changed it to 500 cash or surety. The allegation is you went in this house after you got evicted without permission. But maybe there's more to it. You wish to plead not guilty. Ms. Klein owns a number of houses. So you're not working, you're not paying your fines, you're not showing up for court. And so that's not a good combination. So I'm sorry, go ahead.
I couldn't show up for court. Just the last time I had no ride. I couldn't find any ride to get to court. But I know somebody that can give me a ride, because I had talked to somebody and they said that I could come and help them with work and stuff once it got nice out. All
right. Well, I'll get you a ride from the sheriff. I'll see you on May 17th. Actually, Judge Pattison will. I don't want you to wait all the way till, if someone will post your bond, you can get out. Otherwise, you're going to sit for a few days. What I'll probably do is wipe out that $475 that you owe in the other case. Yeah, that's what you get. For blowing off the court hearing. What?
How long do I have to sit for 2 days or 500?
Yes. It's not 2 days, it's until May 17th.
Oh, okay.
All right.
Okay.
I'm not sure exactly what's going on there.
I don't know.
I had issues with the landlord-tenant case. And as I said, rather than do the bench warrant, because I talked to him, I let him out. I gave him the PR bond. He didn't show up. I don't think he was confused. I gave him the date. He may not have gotten the date for the show cause. I didn't get his address. lives with brother Jacob Warner on Main Street. Three Rivers. But I don't think he's doing real well. All right, thanks for your help, Keith. And unfortunately, Judge Pattison inherits that. But he's dealt with him before. He gave him the original 20 days. All right, thank you.
Yep, have a good day.
All right, we're gonna stop again. We got one more landlord tenant case to do. And then
Every day in the USA, people find themselves in court.
all right, we're back. People click right on that. GB. I don't know what that means. All right. Our next matter is Sturgis Housing Limited, Dividend Housing Association and Limited Partnership. It's a lot. I usually just say Sturgis Houses Limited, Sturgis Housing Limited. They are represented by attorney Samantha Sprague from the Gann Law Firm in Lansing. And also present is Cindy Pennington, their manager. With us here at the courthouse in the conference room is Ora Goodsell. Mr. Goodsell, can you hear me?
Yes, I can.
And Ms. Goodsell, can you hear me?
Yes.
And Cheyenne Goodsell is here by Zoom. I received a letter about 1 minute ago from Cindy Pennington to Mr. Goodsell advising that Cheyenne left in October of 2023. Is that true, Ms. Goodsell?
Yes, it is.
And so you're no longer there?
No, I have not been.
All right, let me take a minute and make some notes here, and then I've got to tell you both something. Everybody that needs to be here is here. You are both tenants in a landlord-tenant case, and you're defendants in a case that demands that you pay the rent. In such a case, you have the following legal rights. You have the right to obtain counsel in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. We sent you that information, and Meg Bauer from Western Michigan Legal Aid is here with us on the live feed. You have a right to have the case heard here in St. Joseph County. You have a right to demand a jury trial. You have to do it today or do it in writing within 5 days and pay the $50 jury demand fee, unless you can't afford it and you ask for a waiver and the judge waives the fee. And we will either tell you where to find that form or provide it to you. Your landlord has asked you to be evicted from a residential property because you haven't been able to pay the rent. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated agency, a housing assessment and resource agency, or a federal homeless veteran program. I just talked to a lady earlier this morning that had contacted all of those agencies, except the veterans one. You should have received that information regarding that with your summons and complaint, and I did send you that. You may be able to read
Every day in the U.S.